Thank you, Eric, and thank you, Gabrielle and Richard, for inviting me. It's a real pleasure. I guess I've preempted a little bit the sensitivity that Don was pointing at by calling my presentation WTO and Public International Law, because I completely agree with you, it is a bit awkward. I've been trying to stay away from this topic for a while now, because it's almost 15 years ago, I wrote a book about this topic, actually under the supervision of Petros, whom we will hear tomorrow. But I think it's actually not a bad moment to look back and say a few words about this topic after all these years for basically two reasons. The first reason is it's now 20 years since the creation of the WTO, and we have actually quite a lot of jurisprudence. So for me to give you some general trends of what has happened in this field. And then secondly, to zoom in specifically on the case that several people have already mentioned. Gabrielle mentioned it, I think also Giorgio, the Peru-Guatemala case, which I think is very technical, but I agree with both of you, it is very, very important, depending on how you look at it. And to disclose everything, I have been on the legal team helping Peru in this dispute, but I will speak completely in my own capacity. So let me start by referring back to a paper I did a couple of years ago with a political scientist, and for lawyers it's not a very good title, The Politics of Treaty Interpretation. Lawyers think, how can there be any politics in treaty interpretation? But I do believe, and we can talk endlessly about all of these topics, I do believe that for the topic we are talking about here, there's ambiguity. And the decision you make is actually an interpretive choice. You make a choice of interpretation, the way you decide to refer mainly to text or context, the way you opt for original or evolutionary interpretation. I think your stance on do we refer to public international law or do we look at ourselves as self-contained is an interpretive choice. Okay, so I don't think there's any correct or wrong answer by definition, because really the interpretation space given to WTO judges is quite large. The contract is incomplete. WTO members cannot get their act together to themselves complete the contract or give further advice as to what they meant. So we need to think about what space is there and how is that space filled by the judges. So it's the states, I think, that give the space to the judges, but then the adjudicators fill that space also by their background. Where do they come from? What do they know about? What is the guiding norm? How are they appointed? So looking back to those 20 years that have passed and trying to kind of get into the minds of these adjudicators, I think there must be competing forces. Some forces plead in favor of looking at public international law. And of course, when I say public international law, I refer to human rights treaties, environmental treaties, customary international law, general principles of law, as a legitimizing factor. If you're a newly established appellate body, you want to refer to other courts, other treaties to increase your legitimacy. Plus, you may want to legitimize yourself as not being just a trade body, but also open to non-trade concerns. Now, the second reason I think that is very important and could explain references to the outside world is that the judges, they want to get some voice from the member states. They want to know what the member states did, what did the international community do, so as to update, get some input from the negotiators, right? Now, against this, and I think Giorgio had a slide on this also over lunch, there is resistance. And again, you can understand that resistance and see where it's coming from. You could say, well, if we refer too much to other treaties, to this outside stuff, we risk the independence of our regime. The WTO dispute settlement system was set up only to enforce covered agreements, so we shouldn't refer too much to these other things. And secondly, and I think this is becoming really important, reference to public international law can also become a threat to the multilateral system, to multilateralism, and in particular reference to free trade agreements. So forgive me the simplicity of these two arrows, but what I'm thinking is that over time, the importance of the legitimizing factor has gone down. I think the appellate body is established. No need to refer to outside law to get legitimacy. Plus, and this is crucial, this is probably the main point I want to make, the WTO has been interpreted so broadly, GATT Article 20, the exceptions, the TBT agreement, to include a lot of non-trade concerns. So there's less and less need to refer to human rights treaties, to environmental treaties, because it's basically all read into the WTO exceptions already. Same thing with the regime independence. I think they are established, and fewer people, fewer tribunals feel at risk referring to this public international law. The bigger issue has become, if I would compare the first 10 years to the last 5 years, I think the main push to refer to outside law is to get feedback from the member states. It is, as I think Giorgio was saying, it is actually quite surprising how the appellate body did go into all of these arguments. In the Peru case, it didn't have to go there. It could have said, the treaty is not enforced and we will stop there. They went at great length on about this FTA and then interpreted without much hesitation. Same thing, the threat to multilateralism is becoming very real. With all the FTAs, today the whole issue about WTO and public international law, it's not so much WTO and environmental agreements, it's the WTO and free trade agreements. It's the threat to multilateralism. Now a few words, and Don hinted at this, I have a paper coming out soon on who are these people deciding WTO cases. Actually, we collected all of them and their backgrounds for the first 20 years. We did the same thing for appellate body members. This morning we heard about how the system is still relatively diplomatic. Now I can assure you the data in that respect confirms that intuition. I mean, if you look at the background of WTO panelists, 88% of WTO panelists have a governmental background, have worked at least 3 years for a government. 57%, and I'm talking appointments, not individuals, appointments, 57% have actually been based in Geneva as diplomats. And only, of course I say only because we are academics, only 18% have an academic background. Now, why is this important? Together with another feature, 52% of panelist slots are from developing countries. 52%, even though the large majority of cases involve developed countries. Now, I think Don, perhaps more diplomatically than I will do, refer to this already. I think having trade insiders, having governmental people, especially from developing countries, will determine how you look at the question we are addressing here. I think as a trade insider, you'll be very much protective of the regime. You'll be inclined not to refer too much to other things. As a governmental official, you will not rock the boat, and probably you shouldn't. And I think for developing countries in particular, the threat to multilateralism is a big issue. They want to really tie their hands, respect the WTO multilateral system, and not see it eroded by bilateral treaties. Now, appellate body member appointments is actually a similar story. If you look at the appointments, and I'm just trying to plot any given year in the last 20 years, of the 7, what was their background? Governmental, academic, trade law experience? Have they been on a court where they negotiate this? Actually, the number of governmental people with a trade law background, negotiators, has gone up, not down over time. It has gone up. And again, here, it's always risky to show pictures, but look at the people who were on the appellate body in the first years. Most of them were not trade specialists. They had a background in competition law and public international law. You had trade specialists, but they came from a wide variety of backgrounds. 4 of the 7 then were from developed countries. Developed. New Zealand, Japan, EU, US. And here we have Giorgio in his nicest outfit on the left. They look very formal, different from the first group, but the thing I want to point out is that still in 2001, you had people with a relatively diverse background. You had people really with public international law skills, people with procedural skills, still quite a number of people who were not at origin trade specialists. Now look at the members on the appellate body today, and this is not to say anyone is better or worse than the other, it's just their background and where they are coming from. It's very much like what I was telling you in terms of panelists, with one exception, and even there, Peter van den Bosche was working for the WTO at some point. They are all having a deep governmental background. They all worked for the government, they negotiated, they were trade insiders. And if you look at it now, only 2 members of the 7 are from a developed country. We moved from 4 to 2 only. Of course, now we have a member from China, we have a South Korean, not a Japanese. So those are developments, those are elements that I think matter in terms of outcomes on the interpretive choice that we are addressing. Now, what can we say about the first 20 years? And Professor McRae referred to this excellent book already. Graham Cook put it all together. There is no doubt that we have a lot on public international law in the WTO. He refers to 1,000 statements on the issue out of 60,000 pages of WTO jurisprudence. What comes out of this? I think first of all, and this is perhaps too obvious to point out here, clearly WTO panels, the appellate body, they do not have jurisdiction to decide on claims of violation outside of the covered agreements. They cannot go on and decide on whether NAFTA has been violated. They cannot go on and decide a dispute under an environmental treaty. Clearly, their jurisdiction is limited to WTO covered agreements only. We have seen, as Graham pointed out, more than 1,000 statements, especially on general international law. And I think Hélène was referring this morning to fragmentation and the risk of will the specialized body interpret international law differently than the International Court of Justice or other bodies? None of this has happened. They have referred very strictly to general international law. They've tied their hands to the Vienna Convention. No fragmentation there has happened. There's no WTO view on treaty interpretation. They follow the Vienna Convention. There is no WTO approach to the rules on attribution. They have really referred quite often to the articles on state responsibility. The other thing, and it's what I mentioned is probably the most important development, they have interpreted the WTO treaty itself very broadly, referring to non-trade issues within the WTO exceptions, making the need for reference to multilateral treaties on the environment, human rights, almost superfluous. You don't even need a treaty to be an environmentalist or to protect human rights or to care about public morals. You can do it unilaterally. Okay? This meant that today, as I said, the real issue is what do we do with instruments, not of general international law, but treaties that have been signed by a subset of WTO members, FTAs. Sometimes you have environmental treaties, human rights treaties signed by a subset of WTO members. How do we address those? And really, this is not a centralizing theme where the WTO comes together in the big family of public international law, general international law. It is a question of how much decentralization do we allow for? How much do we refer, for example, to FTAs? What I'll do here, and I will not at all go through it, I've just put together the 10 cases, the 10 most important cases, I think, in the last 20 years. And just look at 2 things. One is the color code, the title. If it's blue, it means they were open. And look also at the people who were deciding the particular case. I've given you the 3 names on the top left, the appellate body members deciding. Gasoline, we refer to it. Hormone beef, the precautionary principle. The poultry case, very important. You can't make a claim under a bilateral agreement. At best, you can refer to it for interpretive purposes. The shrimp case, very important, referring to environmental texts. The soft drinks case, not so open to FTAs, to the NAFTA. The bananas dispute, referring to bilateral understandings, saying that you can actually waive your right to a panel under a mutual settlement. The aircraft dispute, referring or not to a bilateral aircraft agreement between the US and the EU. And then more recently, the clove and the tuna case, where the issue was how much do we refer to documents that are not part of the WTO covered agreements, but that are ministerial decisions or TBT committee decisions. Very much open to bringing those in. And number 10 is the case I will say a few words about in a moment. So striking to me, and of course it's a selection of just 10 cases, striking to me is how often Judge Feliciano, and he was already mentioned by someone over lunch, Toy Feliciano was on 4 out of the 10 cases. And of course, he was only on the appellate body the first couple of years. If you ask me, he has been very, very influential in the first couple of cases, opening up the WTO to other treaties. The other thing that is really striking is that 9 out of the 10 cases involve the US or the EU. It's only the last one that is a case between developing countries. And if you look at the case law carefully, if you have to point at the biggest opponent to reference to public international law, it has to be the United States. For sure. They are not even willing to talk about it in pleadings, whereas the EU has been the biggest proponent, which I find very interesting. So it's clearly not an issue of the big players do not want to refer to it or want to refer to it. You have an opposition here. And I repeat myself, but the fourth thing that is really striking, the first couple of cases were all about non-trade concerns. Environment, the precautionary principle, things like this. The last 7 have been about FTAs or about internal WTO trade instruments. So there's a complete shift in the debates that we are having. Now here it gets a bit complicated, but what I want to show is that the outstanding issue when it comes to, okay, how much will they refer to outside WTO, to instruments outside of WTO covered agreements? To me, it's useful to make a distinction between, okay, are they willing to refer to instruments that are not part of the covered agreements, but at least still concluded within the WTO, like the declaration at Doha or a bilateral settlement, as opposed to stuff that was concluded outside of the WTO. And equally important is, if they are going to do this, if they can find an explicit legal hook in one of the treaties, they will do it far more easily, far more quickly, than through treaty interpretation, let alone through another process like direct application of an outside law, waiver, consent, or later in time treaties. So let me just give you an example of each. Inside the WTO, they are very keen to refer to this, especially if there's an explicit legal hook. So in bananas, they refer to a bilateral settlement as something that can take away your right to a panel. Outside the WTO, but with an explicit hook, they are still quite willing to do it. The big question now is, would they refer to an FTA clause that waives the right to a WTO panel? Although there you have the explicit hook of Article 3.7 that I'll come to in a moment. If you move to treaty interpretation, it already becomes a bit more delicate. And certainly if you move away to other processes, it has been very hard for the appellate body to directly apply outside WTO covered agreements. They've done so in a few cases, they've done so for procedural rules, but again, the biggest question today is, will they be willing to do any of this for example, free trade agreements, or an environmental treaty, or a human rights treaty that only a subset of WTO members are bound to? So let me close on the particular case and leave many issues for discussion if you wish. I don't have to repeat the facts too much. But basically in that Peru-Guatemala case, you had an earlier FTA where the parties agreed that Peru can maintain a particular measure. Now a couple of years later, what happens? Guatemala challenges exactly that measure before the WTO. The FTA is kind of fuzzy about it, not exactly clear. What did the panel say? The panel says the measure, I'm sorry Peru, but the measure is a violation of the agreement on agriculture. This is a variable import duty. And the FTA argument, they skirted the issue. They were very hesitant to look at the FTA, and they were saying, the FTA is not in force, so what can we do with this? Now, the appellate body confirms the outcome. Peru loses, but what is very interesting, very, very interesting, is that the appellate body has no hesitation whatsoever to look at the FTA. in long footnotes, they interpret the language in the FTA. They find that it's not clear enough. So they don't hesitate to look at this FTA, but they basically decide against Peru because the FTA clause is not clear enough. It's not explicitly taking away Guatemala's right to a WTO panel. And really as obiter, but there was no need for them to go through this, but they did make incredibly important statements on what they view as the process of treaty interpretation. And they've given a very narrow view of the interpretive exercise. So for example, if the text is clear, an outside treaty cannot have any influence on the interpretation. No interpretation contra legem. Although you could say, as I think Giorgio was saying, Article 31 is a holistic exercise where you look at text, context, all of the elements together. They clearly put text as number one. Secondly, they've essentially, although they didn't say it in so many words, they've basically said a bilateral agreement cannot be referred to in the interpretation of the WTO treaty. It has to be the common intention of all members. So no interpretation that is specific to 2 WTO members only. And the third thing is that they were very precise on when an instrument will be relevant. The FTA has to basically say, we interpret the WTO treaty in this or that way, or we take away a certain DSU right. It has to be very specifically dealing with the term of the treaty. And the last point they said, made, again, incredibly important if they push ahead with this, they made a statement that everything that is WTO minus in an FTA must comply with GATT Article 24. In other words, in one sweeping statement, they completely disapplied Article 41, arguably also Article 30 of the Vienna Convention, all of the Vienna Convention, for them to look only at GATT Article 24. So what the appellate body is doing here, I think confirms what I was trying to say earlier. They have no longer the original hesitation of referring to outside treaties. They feel quite confident. Their regime is not threatened. At the same time, the core issue has become that of multilateralism. The issue being, are we willing to refer to an FTA? Are we going to admit WTO minus as a WTO appellate body? And clearly they've said, or very much hinted at, the answer being no. So I will just show you this slide, and to tease you a little bit, I'll refer to softwood lumber. We are in Canada after all. We still have an issue of, can a WTO member waive its right to a panel? And there is this explicit hook that I mentioned. There is a provision in the DSU that says, if you come to us, the WTO, you have to come in good faith. And the appellate body has said, if there's a clear stipulation that you waive your right to a panel, and if it's in relation to the DSU, we will accept it. We will waive your right to a panel, and we will not look at the case. Now, the big issue that is open, and perhaps some of you will say it's not open, others will say it's clearly the case, is whether you can waive your right to a panel in something other than a DSU settlement. For example, the softwood lumber agreement, although there we have some form of a settlement. Is it possible for Canada and the US to say, as they did, you can no longer go to the WTO, we will decide this case under another forum, as they did in arbitration? Is it possible for the EU-Canada Free Trade Agreement on NAFTA to have a forum clause that says, if you've gone to NAFTA or the CETA already, you cannot go a second time to the WTO? Will the appellate body defer to that kind of a waiver of your right to a panel? My answer would be that it has to refer to this. It's equally bad faith if you've agreed not to go to the WTO in some other clause, but it's not very clear from what the appellate body was saying. On the one hand, they say you can waive outside of a mutually agreed solution. On the other hand, they were saying it has to be, or it cannot be beyond the settlement of specific disputes. So that's really the question. I think the bottom line, the line I would draw, is it's not permissible under the DSU, Article 23, for example, for the US and Canada to set up a separate arbitral tribunal to decide on exactly WTO issues outside of the DSU. Outside of the DSU. This would, in my view, be contrary to Article 23, not possible. But if you say, look, we prefer to go to NAFTA, where, of course, NAFTA claims would be looked at, I don't see how this shouldn't be possible. And this is the CETA clause, the choice of forum. So, same thing, not very clear on whether they can contract out of the WTO treaty. And I have lots of ideas, lots of issues that I will write down in paper. But let me conclude. So it's a choice, honestly. We can debate about it. It's questionable, it's a choice, so who decides matters. The big issue today is, surprisingly so, not environmental treaties, human rights treaties, it's trade instruments, and it's FTAs. The appellate body seems to be open to procedural waivers. You can waive your right to a panel, but is not very keen on substantive WTO minors. Now, my bottom line on that is that I see a risk that if all of a sudden the whole of the Vienna Convention is contracted out just because you have Article 24, so nothing that members agree upon in other treaties can actually affect the WTO treaty, the risk there is that you put the WTO on top of all the other treaties. Only internal WTO changes can change the WTO treaty. The risk is that you freeze the WTO treaty in time, you put it above all of the other treaties, and that may ultimately lead to a level of fragmentation. Thank you.